On 27th January 2014, Felista Ngina Mulwa, together with her sister Scholastica Mwikali, were informed that their sister was missing from her house. She went to the house and in the company of her sister-in-law proceeded to Ilasit police station to file a missing person report, but they were instead directed to Loitoktok police station. They continued searching for their sister in various hospitals, but all was in vain. Several days later, on their way home, while near a bus stage near the residence of their sister, a lady crossed into the bush to relieve herself, but immediately she ran back into the road in fright. She beckoned to Felista, and Felista accompanied her back into the bush, only to be met by a dead body. She identified the dead body as that of her sister. Police officers were contacted, and they soon came and removed the body to the mortuary. This is V for Verdict with me, James WaNjeri, and today we highlight one of the cold cases that went all the way to the Court of Appeal of Kenya. And the question is, who killed Catherine Kanini Muiwa? And how much reliance do courts place on the evidence of children? Now, this case was an appeal. In Kenya's court system, at the lowest rank, we have the magistrates' courts, followed by the High Court, followed by the Court of Appeal, and of course, at the very top of the court system, we have the Supreme Court. Kenya has an appellate court system in which if you are unsatisfied with the decision of the court you went to, then you can appeal to the higher court. Now, the High Court of Kenya sitting in Kajiado was informed on 14th April 2014 that one David Munyui Chirago and Samuel Mongai Nganga were suspected to have intentionally and deliberately caused the death of Catherine Kanini Muiwa, who we will be referring to as the deceased person. Accordingly, they faced the charge for the offense of murder, contrary to Section 203 as read with Section 204 of the Penal Code. And the particulars were that the two of them, on or about the night of 25th and 26th January 2014, at an unknown time at Nkama Village, Kuku location in Loitoktok district within the county of Kajiado, murdered Catherine Kanini Muiwa. When they were presented to court, they entered a plea of not guilty to the information, and soon thereafter their trial commenced. At the conclusion of their trial, they were found guilty of the offense of murder. They were convicted and sentenced to death. Now, being aggrieved by the conviction and the sentence of the High Court, they filed the appeal to the Court of Appeal. And basically they were saying that the grounds of the appeal were that, one, basing their conviction on the sole identification of one witness without the court warning itself of the dangers of convicting on such evidence was a ground for appeal, that the court failed to observe that the evidence of the one witness needed to be corroborated. It was lacking, but it was absolutely necessary. The court also failed to observe that the burden of proof was not discharged to the required standard, and that the provisions of Section 169(1) of the Criminal Procedure Code were not complied with, despite the appellants testifying on oath and advancing an alibi defense. Let us look at the evidence that the High Court dealt with, because remember, the Court of Appeal normally will not admit new evidence at the appeal stage. So they only need to look at what transpired in the court below them and then ask themselves, would we have arrived at this same decision? This bench of the Court of Appeal had 3 judges of appeal Makandia, Bogolim Saga, and Hedwig Omondi, justices of appeal. Now, the first witness, who we call Prosecution Witness 1, PW1, was the third-born daughter of Catherine, and she was a Class 5 pupil at a primary school. She said that she used to live with her mother at Loitoktok. On the 25th of January 2014 at about 8 p.m., Catherine left the house to go purchase some flour. After some time, she came back in the company of 3 people. Now, according to prosecution witness 1, she was able to see these 3 people courtesy of a tin lamp that she had lit. Among them were the 2 gentlemen who had been brought to court, David Munyui Chiragu and Samuel Nganga. She knew these 2 gentlemen very well, since they used to frequent their house, being acquaintances of her deceased mother. However, the 3rd person they were with was unknown to her. While in the house, they had a long conversation with her mother, the deceased. The first appellant and the other person who was unknown to her soon left, leaving behind the mother Catherine with Samuel Mungai Nganga in the house. So according to her, David and the 3rd person whom she did not know left, and when they left the house, Catherine was then left together with Samuel in the house. Later, the 2 of them left, and that was the last time she saw her mother alive. As soon as the 2 had left, she retired to bed only to be awakened by a knock on the door, and upon opening, the 3rd unknown man entered and went straight to where her mother kept her money and took the same together with 2 cell phones and left. Her mother did not turn up that night. The following day, she went to school, but her aunt, one Felista Ngina, came for her, and in the company of the head teacher, they proceeded to Loitoktok police station to record a statement. She was again taken back to the same police station sometime in February 2014, and she was asked to identify the person she had seen in their house on the fateful night. She identified the 2 appellants, David and Samuel, in 2 separate police identification parades. Felista Ngina is the one who, together with her sister-in-law Scholastica Mwikali, chanced upon the body of Catherine when another lady had gone to relieve herself in the bush, and upon seeing that, they called the police. The prosecutors also called in a 3rd witness, WaNjeri Wambata. She was the landlady to Catherine, and according to her, she saw Catherine alive on 25th January 2014, going to the market, but never saw her again. She only heard her voice at about 9 p.m. on the same day when she was calling her children to open the door for her. A few days later, at about 2 p.m., she heard screams from the road, and when she went to the scene, she found that the body of Catherine had been discovered. Prosecution witness 4, who was called Joyce Mukulu and was a neighbor of Catherine, said that at about 9:30 p.m., she heard Catherine calling out David to calling out the daughter to open the door. Shortly thereafter, she had her in a conversation with some other people, and after some time, all went silent and she slept. The following morning, which was a Sunday, after the church service, she was informed by Catherine's daughter that Catherine had not returned home. It was much later that she heard screams and saw people gather by the roadside and was informed that Catherine had been killed. The other witness was Dr. Stephen Mutiso, who conducted a postmortem on the body of Catherine on 30th November 2014. He noted that her forearms and thighs had blisters, and there was a puffiness on the face with bruising on her head and thighs. The spinal column and her cervical spine had been fractured, with the spinal cord being severed. He formed an opinion that the cause of death was due to the fracture of the cervical spinal cord due to either trauma to the neck or strangulation. However, he was unable to establish the day or time of death. Police witness John Nyangares Libao was requested by the investigating officer to conduct an identification parade. And according to him, he described how he conducted the parade twice for both David and Samuel, and the child was able to identify the both of them from the respective parades. He confirmed that both parades were conducted in accordance with the police force standing orders. The investigating officer, one Jonathan Munga Mbwana, reported that on 27 January 2014, while he was in his office at Loitoktok, he received a telephone call from the deputy OCS, who then informed him that there was a dead body of a female found in a thicket bush. He proceeded to the scene and caused the scene to be photographed, and the body was soon thereafter removed to Loitoktok District Hospital mortuary. Upon interrogating the child, he started looking for David and Samuel as suspects. He and other police officers were able to arrest them, and a police identification parade was conducted, and they were positively identified by Catherine's daughter. He then prepared an information charging David and Samuel with the murder of Catherine. At the close of the prosecution case, they were found with a case to answer, and they were put on their defense. They all prepared sworn statements of defense. David denied the offense, stating that on the fateful day, he was at his house with his wife and family from 7 p.m. until he went to bed and never left the house until the following morning. He confirmed that Catherine's daughter was well known to him before the identification parade. He called his wife Grace Njoki Munya as his witness, and she testified that David was with her throughout the fateful night and at no time did he leave the house. Samuel equally denied the offense and stated that he was at all times at his house. He only learned that Catherine was no more on 27 January 2014. He knew Catherine's daughter as he used to undertake repairs in their house. He also called his wife, Leah WaNjeri, as a witness. She stated that her husband was on the material night with her throughout and never left. Therefore, the court was now forced to deal with the matter. How come the daughter to Catherine placed them at the house that night, but they've also brought their wives to actually give evidence that they were never there, but they were in their houses for the entire night? Upon conclusion of the trial, the court was satisfied that the prosecution, in their quest for justice for Catherine, had indeed proved beyond reasonable doubt that Catherine had been murdered by both David and Samuel, and proceeded to convict them accordingly. Upon conviction, they were sentenced to death. Now, according to David and Samuel, remember, these are the two who were taken to court and charged with the murder. The third person was never found and was never discovered. In their appeal, they submitted that the judge of the High Court relied heavily on the testimony of the child without interrogating the truthfulness of her testimony and without cautioning itself on the dangers of such reliance. According to them, there were critical witnesses that were not summoned to testify. These included the lady who found Catherine's body and the police officer Ucheng who took photographs of the scene of the crime. There were missing links in the prosecution case, and it created doubt that should have been resolved in their favor. What are some of those missing links? According to them, this included the fact that, number one, the body was found or was discovered by a lady who never testified. An unknown person took money and cell phones from Catherine's house immediately after David and Samuel had left. The time of death could not be ascertained by the doctor. There were several flaws in the prosecution evidence regarding the identification of both David and Samuel. For instance, the intensity of light illuminated by the tin lamp in Catherine's house was not interrogated. How much light was there? What was the position of that light vis-a-vis David and Samuel? Also, what was the distance between the child and both David and Samuel, coupled with the fact that the child, the key witness, was a child of tender years, and therefore there was room for error on her part. According to them, the identification parade was conducted with the same members which offended the rules and regulations governing such parades. Further, the investigating officer who was a witness was part of the team that conducted the identification parade, which was also against the force standing orders. According to them, no evidence of the first report and description of the appellants before the identification parade was laid as required. The appellants was saying that having not called the lady who discovered the body to pinpoint the exact day and time that she could have been killed, and also the failure by the doctor to pinpoint the exact day and time that Catherine could have been killed, was a clear indication that the prosecution did not prove their case beyond reasonable doubt. David and Samuel said that the trial court failed to consider the defense of alibi advanced by them. And basically, the defense of alibi is one that says, I was not in that place, I was somewhere else, and here is a person who can prove that I was somewhere else. One of the things you're going to be looking at is how does a court consider the evidence of a wife, especially when the husband has been charged with a criminal offense? How will the court deal with that? They also said that there was some circumstantial evidence. There was missing gaps in the prosecution's case, and the chains of events had been broken. For instance, one witness had testified that she had people talking and being welcomed into Catherine's house, but she did not see them. Catherine's body was discovered by a lady who never testified. Equally, another witness testified that she did not see David and Samuel when Catherine asked the children to open the door. Of course, the doctor could not establish the time of death. In opposing the appeal, the state submitted that the identification parade was conducted properly and that they were pointed out by the child as she knew them very well since they were frequent visitors at their house. The witnesses that were called by the prosecution were sufficient to prove the prosecution's case against David and Samuel, and there was no need for multiplicity of witnesses. On the question of light, it was the argument by the prosecution that there was sufficient light in the house which made it possible for the child to identify those who had come into the home on that day. Now, the court began by noting that when we deal with a case of murder, the prosecution has the singular task of proving 3 ingredients of murder for there to be a conviction of murder. Number 1, that the death of the person occurred. Number 2, that the death was caused by an unlawful act of commission or omission by the accused person. And number 3, the accused person had malice aforethought as he committed the said act. Malice aforethought simply is the guilty mind, that there was intention to carry out the action. The court began by noting that with regards to the death of the deceased, they agreed with the trial court's finding that there was no dispute that Catherine had been murdered. There was sufficient evidence to that effect. All the witnesses, save one, attested to the death of Catherine, and it was corroborated by the production of the post-mortem report. Indeed, David and Samuel themselves confirmed the death of Catherine. But the big question was it David and Samuel who are responsible for the death of Catherine? Alternatively, did the prosecution prove beyond reasonable doubt that it was David and Samuel and nobody else who committed the unlawful act that led to the death of Catherine? From the evidence that was brought before court, the Court of Appeal was of the view that it was clear that none of the prosecution witnesses actually saw or witnessed David and Samuel, or indeed any other person, kill Catherine. There was therefore no direct evidence linking David and Samuel to the death of Catherine. The prosecution case therefore hinged on circumstantial evidence. When dealing with circumstantial evidence, it is a legal policy in Kenya that the guilt of an accused person can be proved either by direct or circumstantial evidence. What is circumstantial evidence? This is evidence which enables a court to, by looking at it, to deduce a particular fact from circumstances or facts that have been proved. That evidence can form a strong basis for proving the guilt of an accused person, just as direct evidence. Now, for circumstantial evidence to sustain a conviction in any criminal trial, the court has laid down what are some of the conditions that must be met. Number 1, the circumstances from which the inference of guilt is sought to be drawn must be firmly established. Number 2, those circumstances should be of a definite tendency and they point towards the guilt of the accused person without any error. Number 3, the circumstances taken cumulatively, looked at together, should form a chain that is so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused person and no one else. Now, The court said that the only circumstantial evidence that was linking David and Samuel to the crime was that of a child. This was a minor who attested to the fact that it was these two and a third person whom she last saw living with her mother, Catherine, was the deceased person. The other strand of circumstantial evidence that the court saw is that after Catherine had left, the stranger, the third man, came back and took the money and cell phones that belonged to her. Other than the child seeing David and Samuel and a stranger living with Catherine in intervals, there was nothing else that showed that Catherine died under the hands of Samuel and David. To boost their case, however, the prosecution then invoked what we know as the doctrine of the last sin. All right? And basically, the doctrine of the last sin is the idea that when it is not clear who killed a person, then the last person who was with them before their life was taken away is considered to be responsible. That is the idea behind the doctrine of the last sin. And the court, in considering this, says that the last sin theory is that where a deceased person was last seen with the accused person, there is then a duty that is placed on the accused person to give an explanation relating to how the deceased met his or her death. In the absence of any explanation, the court is then justified in drawing the inference that the accused person killed the deceased person. This doctrine of the last sin has been used in Kenya in many ways and in many cases. The prosecution provided their evidence through the child. She confirmed that indeed her mother was last seen alive in the company of David and Samuel. Her evidence was not corroborated at all by any other witnesses. Now, this is very important because if you look at Section 124 of the Evidence Act of Kenya, children ordinarily, their evidence must be corroborated. And that is to say, if a child comes and says you stole something, there has to be someone else who comes to provide that same evidence so that you are not just relying on the evidence of a child, but it has now been corroborated. And part of the reason for this is that children forget things, children can make up things, and it is almost impossible to convict someone only on the evidence of a child. The court was of the view that David and Samuel, while in their appeal, they contested that evidence of the child by stating that, in fact, at that particular time, they were asleep in their houses. This being the case, the Court of Appeal was of the view that it was absolutely necessary for the High Court, which was a trial court, to look for corroboration or other evidence that would have implicated David and Samuel. However, no such attempt was made by the trial court. The Court of Appeal was of the view that even where evidence establishes that an accused was last seen with a deceased before she met her death, it is desirable to exercise caution and look for some other corroborative evidence. The trial court, having failed to do so in the circumstances of this case, it made a mistake. It erred. Okay? Now, given the circumstances of the case, the doctrine could not have been applied here. Because remember, according to the evidence that was presented, the deceased person, Catherine, did not live with David and Samuel at a go. It was also instructive to note that after everybody left, only the stranger came back in the absence of David and Samuel and took Catherine's money and the cell phones. The Court of Appeal asked the question, could this stranger have been the last person left by the appellants with the deceased as opposed to the appellants? How does one explain the fact that when he came back to the house alone, he knew exactly where the money and the cell phones were? The court was of the view that the record did not show the duration of time that had been taken between the time when the last lot left and when the stranger came back. Catherine's body was found some days later in a thicket near her house. There was no evidence from the doctors as to when the murder could have happened. The court asked, is it possible that the murder could have been committed not necessarily on that night or any other day thereafter? Is it also not possible that the murder could have been committed by any other person given the credible alibi defense mounted by both David and Samuel, and which, in the court's view, was not discounted by the prosecution. They had an alibi witness. The prosecution was not able to provide evidence to counter that alibi witness by the wives of both David and Samuel. The court was also asking the question, given that she was murdered near her house, how come nobody heard of any skirmish, struggle, or noise as the offense was being committed? The date and time of death was critical to link the death of Catherine to David and Samuel. It was instructive that Catherine's body was discovered in a thicket near her house 3 days later. The court asked, is it possible that she was killed by any other person and not necessarily David and Samuel? According to the court, those questions, that is why it was necessary to establish at what time or date she was killed. This issue left a lot of doubt in the mind of the court that perhaps David and Samuel could not have been with Catherine shortly before her death, contrary to the findings of the trial court. Given the manner and style in which David and Samuel left her house, could the trial court have rightly inferred common intention to commit the crime? The Court of Appeal said, we entertain our doubts. Now, let's look at the circumstantial evidence. The Court of Appeal was of the view that when you look at the circumstantial evidence linking David and Samuel to the crime, it was that of a single witness who was a minor. Inasmuch as the court had warned itself of the dangers of relying on such evidence, it goes without saying that such evidence required corroboration. When the court looked at the record of the trial court, there was no attempt to corroborate the evidence of the child. In the absence of any corroboration, her evidence was of little probative value. It could not be relied upon, and it proved nothing. Therefore, it watered down yet again the circumstantial evidence relied on by the prosecution. Now, on the question of the identification parade, David and Samuel had said that it was not conducted properly because it violated the police for standing orders with regard to how police identification parade should be conducted. The Court of Appeal was of the view is that the identification parade was wholly unnecessary, worthless, and of no evidential value. This is because the witness, who was a child, by her own account, she knew David and Samuel very well and had interacted with them in the past. They also conceded to that fact. Having known them, there was no need for an identification parade. You only carry out an identification parade where the person was unknown to the victim or to the witnesses. The trial court, therefore, ought to have rejected or placed no premium at all to that evidence, but which it did, and it was an error on its part. On the whole, the Court of Appeal was of the view we are satisfied that the circumstantial evidence relied upon by the prosecution was so weak and tenuous as to be unsafe to find a conviction. As correctly submitted by the appellants, there were so many gaps, missing and broken links, as well as breaking the chain of events, as not to make such evidence unerringly point to the guilt of the appellants. Having found so, the Court of Appeal allowed the appeal, quashed the conviction, and set aside the death sentence imposed on both David and Samuel, and they were set free forthwith unless there were any other reasons to continue holding them. And this judgment was issued on the 17th day of December 2021. Still, the question has not been answered. Who killed Catherine? This is V for Verdict.